Welcome back. Away from the issue of SARS, the rule of law and anti-corruption in Nigeria, ROLAC, the British Council and the European Union have collaborated to educate media practitioners on the plea bargain concept. We have details up next. The Rule of Law and Anti-Corruption ROLAC program is an European Union development-funded program managed by the British Council. Its overall aim is to enhance good governance in Nigeria by contributing to the strengthening of the rule of law, curbing corruption, reducing impunity, and increasing access to justice for women, children, and persons with disabilities. The program is working in 4 states: Adamawa, Anambra, Kano, Lagos, and the FCT. And the first component focuses on the implementation of the Nigerian criminal justice reform agenda. The objective is to advance the timely, effective, and transparent dispensation of criminal justice through support for the implementation of relevant provisions of the Administration of Criminal Justice Act at the federal level and in the states. It's to this end that ROLAC organized this media awareness workshop on plea bargaining. The purpose is to build public support for the application and use of plea bargaining in criminal cases in Lagos State by training the journalist to guarantee fair reportage of its usage.
That sentence always remains the prerogative, discretion of the judge.
Different facilitators took the journalists on various aspects of the plea bargain agreement. It was very interactive, as the journalists also asked questions to help them further understand the concept. The Attorney General of Lagos is represented here by an Assistant Director in the Directorate of Public Prosecution of the state's Ministry of Justice. She says that the plea bargain program is one that the state takes a lot of interest in because Lagos is one of the states with the highest level of prison congestion, and so the public needs to understand the concept. Lagos has dealt with over 230 plea bargain agreements in the last 2 years.
The committee to look into the plea bargain applications was set up over 2 years now, and in that interval we've had more than 230. As at today, at least I'm aware that a few applications still came in today. So that's why I said over 230. And all of them have been dealt with. So far, 80 have been concluded and treated in court. Some of them, of course, the defendants will want to consider another option. Some of them, because of the circumstances of the particular case, the Honorable Attorney General will have to decline. So he declined a few, and then others, the defendants, backed out. Well, we've had different cases, but I think looking overall, majority of them are robbery cases. A lot of the defendants, when they see that at the end of the day they could get a conviction, they have to come up with the option of maybe applying for robbery. And those are majority of the cases we've had a few homicide cases, but most of those that have come up have been robbery cases. Then we've also had a few sexual offenses.
A judge of the Lagos State Judiciary, Justice Yetunde Adesanya, also deepened the discussions with a presentation on the protection of public interest, the interest of justice, and the role of the courts, while a university lecturer spoke, amongst other things, on sentencing guidelines and how the public can understand criminal trials resolved through plea bargain agreements.
One of the main objectives of sentencing guidelines is to ensure uniformity and consistency in sentencing. Because like I explained, for an offense of corruption that is 7 years, the judge can sentence between 1 day and 7 years. But how do you guide what the judge will do within those margins? Now the sentencing guidelines sets out the steps that the judge should follow in arriving at the sentence, and the factors that must be considered, and then how to adjust the sentencing.
Plea bargain is a legal concept that has come to stay. It's been in operation in the developed jurisdictions for many centuries, and it was introduced into our ACJL law 2011. Before that, I think we had it 2007. Essentially, what it does is it has so many advantages. The first of which is that it reduces trial time, it reduces the uncertainty and unpredictability of trial. It also, of course, you avoid the publicity of
the trial, the trauma of the victims of the crimes that's being prosecuted. So with all of these advantages, which far outweigh whatever disadvantages you might think the process has. And then there's so many checks and balances in place to ensure that it's not abused.
ROLAC says the training is not limited to journalists, but will be extended to all critical stakeholders in the administration of criminal justice. And from there, we move on to the courtrooms. Here's a recap of some of the top stories from there.
We begin with the report that the Code of Conduct Tribunal has fixed April the 15th for adoption of final addresses by parties in the trial of the suspended Chief Justice of Nigeria, Justice Walter Onoge, on charges of false and non-declaration of assets. The three-man panel fixed the date after Onoge closed his case with only one defense witness who testified on Monday, April the 1st. Before adjourning the case on Wednesday, the tribunal chairman gave the parties time to file and serve the final addresses and respond. In shortening the length of time, the tribunal chairman said he had to give regard to the purport of the Administration of Criminal Justice Act. And now to election matters. The High Court of the Federal Capital Territory in Buari, Abuja, on Tuesday, April the 2nd, nullified the nomination of Senator Demola Adeleke as the governorship candidate of the People's Democratic Party for the September 2018 governorship election in Osun State. Delivering judgment in a suit challenging Mr. Adeleke's qualification to contest for the office of governor, Justice Uthman Musa held that the plaintiffs were able to prove that Mr. Adeleke did not possess the minimum qualification of being educated up to the secondary school level as stipulated under Section 177 of the 1999 Constitution. The judge said that though he found from the evidence placed before the court that Mr. Adeleke was admitted into Muslim High School, Ede, Osun State in 1976, there was no record showing that he graduated from the school, as his name was not seen in the school's register by 1980. And no fewer than 20 political parties in Zamfara State have sued the Independent National Electoral Commission, INEC, over its refusal to issue certificates of return to the governor-elect and members-elect of the Zamfara State House of Assembly. The suit was filed at the Federal High Court, Abuja, on Tuesday, April the 2nd, by Mr. Ebenezer Adabaki on behalf of the plaintiffs. The other plaintiffs are Mr. Zayanu Haske, Chairman, Forum of Political Parties in Zamfara, the Governor-elect and Deputy Governor-elect, as well as the 24 members-elect in the state. The plaintiffs want the court to determine, given the provisions of Section 133, subsection 1 and 155 of the Electoral Act 2010, whether INEC can question their return and refuse to issue certificates of return to the declared winners. In Lagos, a federal high court has fixed April the 18th to decide whether or not the Economic and Financial Crimes Commission can file additional evidence against former managing director of the defunct Intercontinental Bank PLC, Dr. Erastus Akingbola. Justice Mojisola Olaterugun fixed the date for ruling following the opposition of the former bank chief to the admissibility of some statements of accounts from Access Bank which were sought to be tendered by the EFCC. Mr. Akingbola, through his lawyer, Chief Wala Olanikpekun, a senior advocate of Nigeria, insisted that the EFCC could not substitute a witness or file fresh evidence since investigation has ended and trial has commenced. But the counsel to the EFCC, Rotimi Jacobs, a senior advocate of Nigeria, argued that by virtue of the Administration of Criminal Justice Act, the prosecution was at liberty to file additional evidence any time before judgment. The former bank MD is facing a 22-count amended charge of granting reckless credit facility, abuse of office and mismanagement of depositors' funds, charges to which he has pleaded not guilty. And we round off with a report that the Lagos State Police Command has arraigned one Inspector Oguyemi Olalekan before a Chief Magistrate's Court sitting in Ebutimeta, Lagos. Inspector Olalekan's arraignment on Friday comes barely 24 hours after he was dismissed for his alleged complicity in the killing of Kolade Johnson. Johnson was shot dead on Sunday by a police officer while he was watching a televised football match in the Mangoro area of Lagos. According to a statement on Thursday by the police public relations officer in Lagos, Bala Elkanah, Olalekan and one Sergeant Godwin Oji were apprehended following the incident. Both men were subjected to internal disciplinary proceedings known as orderly room trial, during which 5 witnesses gave their testimonies in the case. At the conclusion of the trial on Thursday, the police found Olalekan guilty of discreditable conduct by shooting and killing Kolade Johnson, among other offences, and was subsequently dismissed. But there was no evidence linking Sergeant Orji to the shooting and was discharged and acquitted accordingly. Inspector Olalekan was then handed over to the Criminal Investigation Department CID Manti for prosecution in court.
And that's our program this week. Thank you very much for watching. Be sure to catch the repeats on air or watch via our YouTube channel. I'm Shola Shieli. See you next week.